Good evening to all. My name is Daniel, alongside with Ana Laura and Pedro. We are coordinating the PósDebate team this term. For those of you who are not familiar with the group, we are a discussion group comprised by and organized by students and former students of the graduate program of law at the University of São Paulo. Today, we're not only having the final event of the year, but we are also celebrating the 7th anniversary of the group. And I see here that our fellow colleague, Luis Fernando Matricardi, who is the founder of the group back in 2014, is also present here today. So to celebrate this occasion, we have the honor to assemble an amazing cast of constitutional and comparative scholars to discuss a very hot topic in the field, and one that is of particular interest to a Brazilian audience, unfortunately. And we are having here today with us two authors and three discussants. The authors are Professor Rosalind Dixon and Professor David Landau. Professor Dixon is a professor of law at the University of New South Wales in Australia, where she is the director of the Gilbert and Tobin Center of Public Law. And she was also recently co-president of the International Society of Public Law, the ICONS. David Landau is the Mason-led professor at Florida State University College of Law, where he also serves as an associate dean for international program. Both Ross and David have just published a book, an amazing book called The Abusive Constitutional Borrowing, a book published by Oxford University Press, and is in the process of being translated into Portuguese. And specifically for today, we're discussing the article Abusive Judicial Review, Courts Against Democracy, which was published by UC Davis Law Review and contains some of the core arguments of this book. So to provide a Brazilian perspective on the work, we have assembled three scholars who are very important for the history of PósDebate in this celebration. Firstly, Diego Werneck Arguelhes is a professor of law at the Insper, and he's also the co-head of the ICONS Brazilian chapter. And he also presented a paper back in 2019 in this group. Karina Denari de Mattos is a lecturer at the Federal University of Rio de Janeiro. And I would like to emphasize that she was an amazing coordinator of PósDebate back in the 2019 term. Conrado Hübner Mendes is a professor of law at the University of São Paulo, a researcher at LAUT, which is the Center for Analysis of Liberty and Authoritarianism, or Freedom and Authoritarianism, and was also, I might stress, the first ever scholar to present a paper in this group. So it's very nice to have you all here. And as in previous events, we are going to keep our tradition of providing a very open and horizontal forum for discussion. So I'll pass the word to Anna to specify the ground rules. Thank you.
Thank you, Danielle. Thank you very much for Professors Dixon and Landau, and the discussants, Professors Diego, Conrado, and Karina. So I would like to emphasize that even though it's a celebration and we have three discussants, but it's still PósDebate and it's still a debate. So we encourage questions and an active participation after the first three rounds of debate, and it will work as follows. So first, we will give the floor to Professors Dixon and Landau for a brief introduction, and then we'll have three rounds of debates. Each discussant will make comments on the paper, and the Professors Dixon and Landau will have the opportunity to react to them. And then after those three rounds, we will open the debate. We wish, just like Danielle said, we wish this to be a horizontal debate, and then and this is why we encourage the active participation. And we would ask the audience to use the chat to show that you're interested in asking a question, and then we can know how many questions there will be and know the order in which we will call you. So that's it. Maybe Professors Dixon and Landau, the floor is yours.
Thank you so much, Anna and Daniel, and for the invitation for the group. It's lovely to be joining you, and we're very grateful to have three such distinguished commentators engaging with the work. I also want to acknowledge that Daniel has agreed to try and translate the work for us into Portuguese, and we're very excited about that and look forward to that as an opportunity for this work to contribute to Brazilian debate. Unfortunately, as you know, this work has relevance to Brazil right now. And one of the things we did when we wrote the book was we made a quite conscious decision to illustrate the breadth of the dynamic that we talk about across a wide range of countries and continents, but not to try and do every case or every example that fit the pattern, because we were very careful to make sure we knew the facts of the cases that we were analysing in sufficient depth to be confident that we had it right. We've been pushed by some people since publication on Israel and a couple of other examples, but we are pretty confident that we've called it right. And Brazil was a case that we debated a lot, the inclusion of, and we decided ultimately not to do a detailed case study, but we're extremely interested in your thoughts. And indeed, if you're a early career or doctoral scholar, would really encourage you to take up where we left off and write your own take on this dynamic as it pertains to impeachment, the rule of law, COVID, national security, and the discourses currently circulating in Brazil. So David and I are just going to divide our remarks into three broad parts. I'm going to talk a little bit about what is abusive borrowing and what underpins it. David's going to give you a couple of illustrations, and then in the third part, he'll start and I'll finish on solutions or potential responses. We want to leave plenty of room for discussion. We do note that all of you have seen a published article called Abusive Judicial Review, and our commentators have seen the whole manuscript of the book. And if you're an early career scholar who hasn't been able to access the whole book and you need to do so, just contact us and we'll see what we can do in terms of getting you access. So the book is entitled Abusive Constitutional Borrowing, Legal Globalization and the Subversion of Liberal Democracy. And it basically tries to focus on the intersection of what we see as two broad trends in the world today. One trend is the progressive globalization of legal discourse, including constitutional discourse. Look at the Zoom that we're having today, where joining from the United States and Australia in Brazil. These kinds of meetings are increasingly common. Ideas travel, and ideas around constitutional design, interpretation, and liberal democracy travel. And for the most part, we've seen that as a positive development since 1989, as a force for liberalization and equality and democracy. The second kind of current is a current which is increasingly the subject of study by us as comparativists and constitutional scholars, which is the decline of liberal democracy in many countries where it was previously seen as established and healthy. David, in his earlier work, called this the problem of abusive constitutionalism. And together we have talked about it as a problem of abusive constitutional change and abusive constitutionalism of varieties of kinds. And of course, this intersects with others' work and ideas, labels like democratic backsliding, decay, rot, erosion, and the kind of anti-constitutional populism that some people like Wojciech Szyderski use as their preferred title. But the phenomenon is clear, even if the label isn't. It is essentially an attack by would-be authoritarians on the substance of liberal democracy, often without dismantling its form. And in this book, we talk about the unification of these two broad trends and suggest that contrary to our intuitions that comparative constitutionalism is always a force for good and for constraining abusive constitutionalism, it's increasingly becoming an instrument of its prosecution, so that liberal democratic ideas are being used and abused by would-be authoritarians, both to first inspire and second to legitimate processes of anti-democratic or abusive constitutional change. So that, if you like, the circulation of comparative ideas is being used to undermine rather than protect democracy, although obviously it's both. we are calling attention to the dark sides of our collective practice as a community. So the second thing I want to highlight is the weak and strong variants of what we mean by abusive borrowing, as well as the 4 specific techniques that overlap, but which characterize abusive borrowing. So as to variants, in the book, we note that abusive borrowing can have a weak or a strong form. And the strong form is where there's some sort of knowing or intentional misuse by a political actor of liberal democratic norms and ideas in order to subvert democracy. And one of the things that David and I have worked on now for several years is to try and particularize what the definition of democracy is that we should employ in this context. And we suggest that it is useful to adopt a relatively thin definition that is not purely procedural, but which is capable of attracting agreement among all reasonable political and constitutional theorists, and which indeed is emblematic of an overlapping consensus among actual democracies as to what democracy requires. So let me just note the 3 requirements of that standard before I go on to talk about what weak abusive borrowing is. So the democratic minimum core consists in 1, regular, free and fair elections among multiple parties. 2, a set of commitments to at least minimum political rights and freedoms. And 3, the forms of institutional checks and balances necessary to protect 1 and 2. So that's the democratic minimum core that we employ throughout our work as the benchmark for judging abusive constitutional changes. And we say that abusive borrowing can be knowingly or intentionally designed to erode the democratic minimum core. That's the kind of strong form that involves bad faith. But there's also a weaker sense in which sometimes changes may simply adversely impact the democratic minimum core without us being able to identify that kind of intent. So it can be strong or weak, but the consistent benchmark for judgment is the democratic minimum core. The second thing to highlight is the 4 different ways in which borrowing occurs. When legal ideas travel or are transferred or migrate, all these metaphors are flawed. None of them fully capture the idea. And of course, borrowing itself is a highly figurative usage that isn't a literal description of how ideas travel. There's always a loss of context. Gunther Frankenberg famously argues that there's a radical decontextualization, but we suggest that the decontextualization is more a matter of degree, and that abusive borrowing involves a kind of radical decontextualization of one of 4 overlapping kinds. First, radical superficiality in borrowing, so taking just the form without any of the substance. Saying we're going to take the right without any intention of honouring it would be a classic example. The second form is radically selective borrowing. You take, say, a prohibition without a defence. You take a set of norms that are designed to operate in the context of political competition without some of the guarantees of independence or competition. Relatedly, a third mode is radically acontextual borrowing, taking, for instance, institutions designed to protect judicial independence and protecting the judiciary and putting them into a system where the court is not independent and where protecting judges is in a sense protecting authoritarian judicial review. The fourth mode is one we think is just as, if not more important, but the least noticed, which is what we call anti-purposive borrowing. That is taking a norm that's designed to do X and applying it to do exactly not X. So take Speaker's Corner in Hyde Park. Any of you who in the long distant past have ever had an opportunity to travel would know that in London, there's a small part of a famous park called Hyde Park where they have Speaker's Corner, which is designed to provide total free speech for anyone who wants to stand up on a wooden box and speak. But Cambodia and Singapore have adopted a Speaker's Corner opposite the police station in a ringed off area as a way of surveying and limiting speech and suggesting that all other speech cannot be allowed and that it is only allowed right there in the baking heat opposite the police station. It's a form of anti-purposive borrowing. All four forms exist, they overlap, and one of the aims of the book is to show that distressingly they are an increasingly global phenomenon. I want to turn over though to you, David, to just talk about some of the examples that we highlight, especially in the book. And of course, David's expertise in Latin America features heavily in the book in a way that should be of interest to your group, because it means that there are quite a number of very important and interesting Latin American examples, you know, in no small part due to David's expertise. David.
Great, thanks so much, Ros. I'll speak briefly about this, and I guess what I would link it to is kind of, you know, who are the actors who are engaging in this kind of abusive borrowing, right? And I think, you know, since you've all looked at the article on judicial review, I'll focus maybe on courts, right? I think there are a number of actors and examples that we go through in the book. Many of them are not judicial, actually, right? They're like, there's examples that are essentially like legislative or executive in nature, where you see a piece of legislation, for example, or a practice being borrowed from somewhere else in a way that is essentially abusive using our definition. And we go through a few examples along those lines. You know, we look at the abuse of gender quotas in Rwanda, for example, the abuse of memory laws in parts of Eastern Europe and in Russia. So there's a big range of stuff that we're drawing on. But I do think it's kind of interesting. We developed both in the article and the book, and unfortunate, right, that one of the more prolific abusive constitutional borrowers are courts in certain environments, right? So courts themselves engage in this kind of tactic, and it's kind of abusive in two senses, right? When we talk about abusive judicial review, there's kind of this double sense, I think. One thing is that courts themselves can become an instrument of a regime, right, to carry out a set of ends, either to sort of rubber stamp stuff or kind of more interestingly, to sort of clear obstacles for a regime. You know, in the other sense, courts are very frequent borrowers of these kinds of doctrines in ways that are problematic. So we'll just go through, you know, I think in some depth, like a couple of the examples from both the book and the article, one of which is right to re-election in Latin America. Many of you are familiar with the use of doctrines like the unconstitutional constitutional amendment doctrine across Latin America. The quite celebrated Colombian case, which deployed the doctrine to stop President Uribe from potentially getting a third term. But then you look at the use of these doctrines, right, as many of you know, across other contexts, and it's essentially abusive on our definition in that they're used at the behest of powerful presidents to get rid of term limits, right? So in the Colombian case, they were used to protect the term limit, prevent Uribe from having a third term. But by far the more common use, and you can sort of track the migration of this doctrine across Latin America, has been actually to uproot term limits in different ways, right? Whether by kind of legitimating or clearing a path through which leaders could get rid of a term limit using an amendment process, despite restrictions in that process or seeming restrictions in that process, or by just getting rid of the term limit. You know, what Roz and I call in the article in the book kind of the strong form of abusive judicial review, right? These examples are very striking. I mean, you know, point to obviously Nicaragua, right, Honduras, Bolivia as examples of this kind of the migration of this sort of logic, but you also pick it up in its kind of weaker form elsewhere in the region, Ecuador, for example, Venezuela. In all these cases, what you have being developed is the idea of a right to re-election, right? The idea that there's a human right to re-election that's being infringed somehow by these term limits. And so the abuse, I think, is very interesting. It's like an abuse of the unconstitutional constitutional amendment doctrine, which is something many of us talk about, right? Or even weirder stuff that's related to it, which I can get into, because it's not all unconstitutional constitutional amendments. Some of it is like the uprooting of the original constitutional text, right, as we know happened in Honduras and Bolivia. But also the abuse of a kind of international human right by sort of misstating what that human right is and what proper limitations on that right would be. And a lot of it engages, in a kind of abusive, superficial way with things like inter-American jurisprudence in the inter-American court, for example. So that's, I think, quite an interesting example of that kind of abuse and the way that courts engage in it. Another one that we go through in the paper and the book is Venezuela, where there is a, after the opposition wins control of the Congress or the legislature in 2015, the Maduro administration uses a number of techniques to basically nullify the power of the legislature. And one of the major ones, particularly earlier on, was the Supreme Court. And the Supreme Court continues to play an important role in that sense. I was just listening to a report the other day by Raul Uribarri, who did the kind of global review for Venezuela, global review of constitutional law for Venezuela for last year. And the court continues to play exactly this kind of a role, where it's basically aiding the regime and repressing the opposition. But in this period, like this 2015 to 2017-ish period, the court was extremely active in essentially stopping the legislature from doing anything, often using kind of liberal democratic doctrine to do it, right? I mean, the most infamous of the cases and bizarre was the one where they declared that there was a legislative omission. They held the legislature in contempt over the failure to resolve elections in 3 seats in a remote region of the country. Then based on that, they stopped the legislature from doing anything. They finally held that there was a legislative omission because of the work of the Supreme Court, the legislature was unable to act. And because of that legislative omission, which is a liberal democratic doctrine that comes out of like neo-constitutional ideas, they transferred all of the power of the legislature to the court, or as they said in the decision, anyone of their choosing, right? Which meant the president, of course. They backed off that last decision slightly, but not that much, right? After getting enormous pushback, even domestically. But I think that's another really interesting example of how it's not just that courts are doing dirty work for regimes, but that they are using liberal democratic doctrine to do it. A last example I'll just mention extremely quickly is like the attempt to like use militant democracy doctrines to ban parties in places like Cambodia and Thailand. We go into these in quite a bit of depth in both the paper and the book, but I think they're really interesting. Also, the way that this very powerful tool, which is meant to protect democracy, right, can easily be turned into something that basically eradicates a democratic opposition in a very straightforward way in Cambodia, where the story is quite simple. The opposition gets banned, and then the ruling party re-wins like all of the seats in the legislature. So it sort of stops the democratic transition from occurring. In a more complex way in Thailand, where I think there is some resonance, which perhaps we could talk about in discussion between like the Thai case and the Brazilian case. I think it's quite interesting, where the role of the court is relatively ambiguous, right? Where there's more complexity in terms of the role the court's playing. It's not a straightforward story of like capture as it is in places like Venezuela or Nicaragua, but there's this ambivalent but very interesting and potentially democratically problematic role that the institution is playing. With that, I mean, I'll say a couple words just about solutions, which is the end of the book and also the end of the article. There are some implications perhaps for design or structure. We plan on exploring that more in a forthcoming book, actually, a project we're working on now. But, with respect to courts, the fact that nullifying the power of the court is not the worst outcome, like weaponizing the court against democracy is the worst outcome, may have some implications that are interesting for the design of a judiciary. A lot of our other implications are just kind of normative, right? We're really talking about ideas. One of the interesting ones is about our own responsibility as comparative constitutional scholars, along with that, others like designers, how we should talk about and think about ideas. And the most extreme implication would be that some ideas are so prone to abuse that they shouldn't exist at all, right? And we generally reject that notion, but we think it should be considered. More realistically, we think that there's a responsibility that we ought to think about as a scholarly community, and it's kind of a transnational community, about how better to abuse-proof, if that's the right word, norms, right? So think about the way we discuss norms and the manner in which we can, at the margins at least, make the norms we are promulgating and disseminating that are part of this discourse that creates the framework within which this kind of abuse can happen, how we can limit the kinds of abusive uses. Not an easy task, to say the least, right? But one that we think is urgent. I'll stop there. Roz, did you want to add anything, by the way?
No, that's terrific. Thanks, David.
Thank you, Professor Dixon and Professor Landau, for this brief introduction to the main arguments of the article. We will now give our virtual floor to our first discussant, Professor Diego. But before that, I would just like to briefly emphasize something Daniel wrote in the chat. As Anna anticipated, we will later be collecting questions from the audience. And for those of you who happen to feel more comfortable formulating your questions in Portuguese, that is no problem at all. We can translate them to Professors Dixon and Landau. But well, without further ado, Professor Diego, the floor is yours.
Thanks so much, Pedro and Rosalind and David. It's great to be here, and Karina. And I would like to thank Danielle for this very kind and wonderful invitation. And yes, I presented a paper here at PósDebate a couple of years ago, maybe 3 years ago, and I think it's a wonderful space that you guys have nurtured over all these years, and it's great to be here to celebrate this endeavor. So I will begin by going back to the definition of abusive judicial review, and I'll focus mainly on the paper and try to raise some issues that might help foster perhaps a dialogue on the Brazilian case and other cases. And you define abusive judicial review as intentional attacks by courts on the core of, or through courts, on the core of electoral democracy. And the problem with this practice is that it masquerades as a legitimate one, borrowing the mantle of legitimacy that constitutional courts and the discourse and practice around them took decades to establish. And this is a very important paper that sharpens and challenges our normative commitments, while it also expands our comparative vocabulary. And it is in this perspective that I will briefly raise a few questions, focus specifically on how to apply and understand your definitions and concerns when applied to a case like Brazil. So when you discuss the definition of abusive judicial review, which I will say AJR from now on for brevity's sake, you discuss the effect of judicial decisions as a key element. And you talk about court decisions that make the political order move closer to authoritarianism. And this happens in two different modalities. First, the weak form, where courts are not the direct agents, but wrongfully passive legitimizers of actions by the other branches that undermine democracy. And second, the strong form, when courts directly undermine this minimal core. And my questions, they largely center on these definitions and their comparative and normative implications. So first, I think it might be fair to say that beyond a minimum core of electoral democracy, your argument assumes, one, a certain level of power by a constitutional court, 2, certain features of the constitutional order that are not part of the minimum core of an electoral democracy, and 3, a certain legal culture around the court and on the constitutional order that gives judges ample room to perform constitutional review. So consider the following example. Suppose we have a given country in which there is no eternity clause in the constitution. Courts so far have not read such a power into the text, and existing legal scholarship, while supportive of a moderate role for constitutional review, is overall critical of judicial activism. So in this country, if an authoritarian leader musters support in Congress to amend the constitution to eliminate term limits, for example, and we have good reason to believe that this might be a path that undermines democracy in the near future, should the court invent a basic structure doctrine? More generally, if a court sees an opportunity to invent a power for itself in a context where inventing this power is necessary to protect democracy, should it do it? And if it doesn't, is it committing weak form AGR, according to your view? And I understand, and I really appreciate that your argument is highly sensitive to local context, and there's a lot of nuance in how you apply these concepts. But rephrasing my question, my first question, isn't there a set of features of strong constitutional review, especially a highly empowered court with broad latitude to interpret the Constitution, that is an implicit baseline of your argument? So maybe your argument has a minimalist conception of democracy combined with a maximalist conception of constitutional review. A variation of this problem, which will lead to my following comment/question. How should courts behave when a given constitution has certain features that, while not necessarily anti-democratic, might be exploited by authoritarian leaders? I'll call those dangerous features, not necessarily undemocratic, but dangerous. So in Brazil, for example, we have learned that when the Senate and the President agree to appoint a docile Attorney General who is interested in being appointed to the Supreme Court, it becomes extremely unlikely that the President will be investigated, much less prosecuted, while still in office. And Conrado here has discussed this problem in the last couple of years. So this is a feature of the Brazilian Constitution that has greatly protected President Bolsonaro, but it has also made the Supreme Court first more vulnerable, and then, as it sees the opportunity created by this flaw, more powerful. In Bolsonaro's era, in part due to the Attorney General's inertia, the court expanded its criminal powers. On April 2019, I'll give you just a little detail that is perhaps unnecessary, but I'll take my chances just so that the argument makes sense. On April 2019, the Chief Justice announced an unprecedented reading of the court's internal rules of procedure. In case of online crimes committed against the judges, their families, or the honor of the institution, the Chief Justice could appoint a fellow of his justices to head investigations, to investigate these potential crimes. The usual path, according to Brazilian law, would be for the Attorney General or the federal police to begin investigations before a lower court. But no such institutions had come to the court's defense in 2019 and 2020. And while the court cannot do much to Bolsonaro himself with these proceedings, these investigations have affected several of his allies, including his children, and discouraged many others. And this has been a key component in the court's relative success in constraining Bolsonaro's attacks. So the way that the Attorney General's office in Brazil is designed is not undemocratic. I'm not claiming that, but it can be potentially dangerous. And when it does become dangerous, what should we expect courts to do? To preserve their role as constitutional judges, or to begin fixing the law by changing it through interpretation? Should they be judges who do their best to defend democracy within their institutional limits, or should they be defenders of democracy who decide by themselves when the danger is just too high for institutional limits to be respected? I honestly have no answer to this question, and it's certainly not rhetorical. Now consider how these things play out in time. You discuss examples of courts reaching potentially undemocratic outcomes for prudential reasons. You consider this possibility more in the case of weak form abusive judicial review, that is, when a court fails to act against undemocratic measures by the other branches. branches, and you consider one example of wrongful acting in the strong form of AGR in the case of militant democracy decisions that remove certain actors from the political arena. But consider that constitutional courts do not just use powers they have, they sometimes also face a choice of inventing and expanding their competences in a way that, however important it might be in the short run, might also be a step away from the minimum core of electoral democracy in the future. There is a legitimate debate in Brazil right now regarding the future of the Brazilian Supreme Court's expanded criminal jurisdiction powers. So this expansion has been decisive in restraining the Bolsonaro camp, and I certainly think it was decisive and important. But in the normal times we hope for in the future, this might remain as a dangerous element in the constitutional order in itself. And the court will surely not simply say, now that the danger has passed, I don't have such powers anymore. Which leads me to another and my final point. In the paper, there's an insightful discussion of a potential paradox. The more legitimate and independent a court is, the higher the price and the usefulness for the authoritarian leader in capturing or dominating it. But consider what happened in Brazil. The court has been largely successful, relatively successful at least, in constraining Bolsonaro's attacks. But while criminal jurisdiction shaped the court's current political clout, it also heightened internal divisions and exposed the court to complex ongoing dynamics of delegitimation. Although confidence in the court has increased in the last few years, in the latest Justice Confidence Index published by researchers from FGV São Paulo, almost half of respondents agree that, quote, the STF justices are like any other politicians, end quote. Almost half. Public support for the court's recent use of punitive powers to protect itself is largely a product of Bolsonaro's threats to institutions and to public health. But when this empowering context is over, the court will face the challenge of rebuilding its standing. So here's my last question. Returning to the paradox you mentioned, I suggest this alternative scenario. Instead of a dichotomy between an independent court versus a politicized court, maybe we can consider the scenario where a court is seen as politicized against the authoritarian leader. A politicized, pro-democracy court who is perhaps self-aggrandizing. So this is a scenario I would like to consider. And courts can be politicized, seen as politicized, at least for your argument, and opposed to the authoritarian leader, a possibility I would like to hear more about in your view. And even people who are critical of Bolsonaro and support the court's recent stance might hold this view, and it poses a special danger. Not only the powerful court is a loaded weapon that can be used by future authoritarians, as we discuss in the piece, but a loaded weapon that is, however publicly supported, already seen as politicized. So this is a high-stakes separation of powers game in which, on the one hand, the court has more freedom to curb the authoritarian threat in the short run. But on the other hand, this path might burn institutional legitimacy like cheap fuel, and it might make much easier for Bolsonaro appointees in the future to help him undermine democracy. And even if we do get rid of Bolsonaro in 2022, perhaps our constitutional order will be less democratically meaningful because of the Supreme Court's expansion of powers to supervise speech and public criticism. Not now, but when the danger has hopefully passed. So these are my comments. I would like to thank you very much for the invitation and for the opportunity to discuss the piece.
Well, before moving on to our next discussant, Professors Dixon and Landau, we would like to offer you the opportunity to react to Professor Diego's comments and maybe do a sort of a ping pong section as you wish.
We're happy to go now or to wait for all three, whatever is most convenient.
It's up to you and Professor Landau, as you feel more confident. You can react now.
Ping pong is always good. David, did you want to say anything to start with?
You can start, Russ.
Okay. So I think, Diego, your comments are very insightful. I mean, they pick up some places which this book doesn't go, right? Which is, when can courts effectively counter the risk of abusive constitutionalism and under what conditions? and when should they hold back in a sort of prudential spirit? I think David and I both have thoughts on that. And to some extent, that is future work. You know, I've written with Sam Zakharov a piece called Living to Fight Another Day about when courts should hold back and when they should build up their legal and political legitimacy to intervene later. I have a parallel project that is a book coming out next year called Responsive Judicial Review that tries to tackle some of those questions, but they're very difficult questions. And David and I have this ongoing project, which is when we started this book, we thought, well, this book is so hard to write because, you know, the world is moving so fast. This book is about everything. And so we decided to split it into two. One is a kind of noticing a problem, and the second is more solutions oriented. And in the solutions oriented book, we're going to talk about a number of principles that guide designers and construction by courts, including, you know, the kind of timing of decision making as well as how they approach it. So you press on a deeply important point. I agree completely that the conditions for successful judicial review are beyond the minimum core, and we don't answer it here, although we have some thoughts about it. And it's basically that you've got to time judicial review and decide its scope and the remedies used very carefully to, in short, combine weakness and strength in just the right combination. You did note, however, one aspect that I think is absolutely on point for this article and broader book project, which is the expansion of criminal jurisdiction in the Supreme Court as a useful tool for combating some of the excesses of Bolsonaro's actions, but which lays dangers for the future. And that is one of the things we really note in the concluding parts of the book, is we say, when you're a constitutional democrat trying to come up with solutions to current problems, whether it's the unconstitutional amendment doctrine or the expansion of criminal jurisdiction or the impeachment of bad guys, you need to be more mindful of the fact that the bad guys are going to come back later, and they are going to take whatever you do now and use it in a way that is potentially abusive. And the broader the kind of powers you delineate now, and the more work you do to legitimate those powers without, you know, meaningful constraints, the more likely it is that you'll see abuse in the future. And so the expansion of criminal jurisdiction, I think, I'm not sure if David would agree, but is really a classic instance of, like, it makes really good sense now, right? But it's a absolutely ripe for abuse kind of doctrine. You know, I gave evidence before the US Supreme Court's commission, the White House's Commission on the Future of the Supreme Court. And one of the things I said to them is, if you're going to pack the United States Supreme Court, you've got to know that the rest of the world is watching. And the first thing that will happen is Brazil will say, well, now we can do it too, right? And so when you design change and new institutional norms, you have to worry not just about the now, but the future for abuse. And expanded criminal jurisdiction might well be just that. David, did you want to add anything?
Yeah, just a bit. These are great comments, Diego. We really appreciate them. They're very helpful and I think very thought-provoking about questions that surround the paper, in a sense, about both the ability of courts to stop other actors from engaging in abuse and the long-run effects, right, of the kind of activism the courts might need to carry out. The one point I would highlight here, I think, that is really interesting about the Brazilian case, as you're laying it out, right, and we're laying out elements of it, is we sort of make an assumption that most of the cases we focus on, to be frank, are cases where, like, the courts are straightforwardly abusing the democratic order because they're acting at the behest of a regime, you know. So there's some group in power that is basically spurring the court to usually serve like a powerful executive's interests, right? That's the kind of classic case that we're playing on. I think some of the more interesting cases of the kind of phenomenon we're describing, but also one that requires a little bit maybe of a expanded thinking of the phenomenon itself, are cases where there are anti-democratic actors surrounding a court, but they're not a regime per se, right? There's kind of other forces that that are not necessarily the incumbent government that are involved. And like, so I think like Thailand, which we go through in the book more than the article, is kind of an interesting example where you have this, like what some people have called, I think, the network monarchy, kind of surrounding the Thai monarch in a way that is kind of suspicious of the democratic sphere. And those actors consistently are disqualifying like democratic parties and actors that themselves pose some threat to democracy, right? But they're being opposed by this kind of group that, in other words, it's not the incumbent using the courts, it's the court being used by a broader set of interests to sort of check democratic majoritarian actors in ways that itself are problematic. And I just think, as I mentioned before, that to me, Brazil always reminds me of that kind of complexity, I think, right? Where there's a bunch of different things going on, but one of the worries I think you raised, Diego, is like, if you create this expanded set of powers in the court, the question is kind of going to be, what do these things get used for down the line, right? Once Bolsonaro's out of power. And I think, particularly thinking back to the Rousseff impeachment, right, and events surrounding that, I think there are significant questions along the lines of like, what, you know, there's no guarantee that even if the courts are not captured, that they're going to use their powers for pro-democratic ends. Like, generally speaking, I tend to think, if you look empirically at cases, the judiciary is less of a threat to democracy, right, than kind of things like executive interests, to be frank. Like, Roz and I have written elsewhere, kind of thought elsewhere about the problems of courts aggrandizing themselves for their own benefit, right? But it's a different problem, I think, to some degree, that may tend to have less direct anti-democratic consequences in most cases, right? Even though it's a significant problem. But if the courts are kind of backed by a diffuse but somewhat anti-democratic set of interests, then I think that game changes, and you have what one might call a sort of more complex example of abusive judicial review.
Thank you, Professor Dixon and Professor Landau. Thank you, Professor Diego. We will now move on to our next discussant, Professor Karina. The floor is yours.
Thank you so much, Pedro. First of all, thank you so much for organizing this panel and inviting me as a commentator. Thank you. It's a pleasure to welcome today Professor Ros Dixon, Professor David Landau in the 7th anniversary of PósDebate. Just a few words before I start. My story with the PósDebate initiatives goes back to its very beginning in 2013. And since then, I've participated in many roles as debater, but either presenter or in coordinator in 2019. And always in all these positions, I saw the hard work of the team and the recognition by participants and academia. So I'm really happy to be here at the 7th year of ongoing discussions in public law in such challenging times. And I'm sure that the format of this open and horizontal place, it's an academic important safe spot for provocative and innovative ideas like the ones we're talking about today. So thank you, coordinators, for the invitation, and Luis for being here today. Well, with that in mind, my contributions today will be focused more on the broader picture of the book project, which the manuscript was given access to us by professors. And since Diego brought the first part of the concept more on abusive, I will focus a little more on the second part of the concept about borrowing. And then as a second comment, I will bring 2 comments today. And the second comment, I am to focus on the methodological challenges that this amazing comparative endeavor must have been, you have been experienced in this project. So in so many countries and different cultures. So first, I believe this is a very successful project and takes on a very important questions and deals with it very well. And what I get from the book as its main contributions are first, the provoking reflections on this paradoxical phenomenon of political and judicial leaders that engage in a global constitutional dialogue, but not to advance rights or to promote institutional adjustments, but to improperly use or even to subvert these ideas to promote attacks on liberal democracies. And second, I think that it's most important in the book is naming and framing when that happens. So, and consequently, this kind of framework empowers us scholars, young early career scholars and graduate students to recognize those abuses and even propose ways to frame our own experience and how to deal with it. So in that sense, I think this is a very empowering and transforming theory that can help scholars all around the world to mobilize these theoretical tools and to fight against these slippery ways in which autocrats perform their mandates and can erode democracies worldwide. And this is really interesting because it happens more frequently than we expected and in many different ways. So the typology of 4 models is amazing to check what is happening. And it's amazing also how you gather, assemble, and illustrate cases that are understudied by literature, most famous, and also the cases who are understudied by literature. So I think this is really important and an amazing piece of work, and we're very glad to comment on that today. So I was reading the book and I was wondering, and maybe that's not part of the project, but first I would like to say a few words about the framework developed, and then to the methodological tests I mentioned. So my first comment is related to the premise about the migration of constitutional ideas, in which the idea of borrowing lies on. So the reason for that comment is that I'm currently also developing a comparative study on diversity in the composition of high courts in 52 American and European democracy in the past 20 years. And by now, we found in our sample that coming to global legal of academic networks, we see that 1/3 of the justice from South America, Central America, and Caribbean courts, they have a stage of their academic careers in the United States or European countries. But on the contrary, only 1 member of the US or European courts came to the South America to earn a degree, and it was in Chile. So even among US and Europe, you don't see in their educational path this kind of network this connection. So what I want to stress in my comment, and based on this previous experience, is that legal networks and legal knowledge globalization do not occur in the same way and never to the same degree. So even though the inspiration for constitutional innovations does not come from colonial relations anymore, the patterns of legal education also reproduce these global hierarchies in the production of law and the complexities of global inequalities in knowledge production and exchange in the legal field. So the book raised this in some passages. First, in the introduction, you mentioned that the club of high-profile courts and justice has been expanded to the global south. And then you mentioned 2 brief examples on how constitutional practice have had great influence in the country you mentioned, both the doctrine of proportionality and also the unconstitutional constitutional amendment doctrine, which both of them have roots in Germany and then migrated to Latin America and many countries. And in the chapter 3, you also mentioned the idea that the legal transplant, the notion of legal transplant evolved since the 70s. And you mentioned how you can recognize when that happens, but you mentioned that there is an ambiguity in the identification of the exact pathways through which designs, doctrines, and concepts have traveled, and how you don't mention how these are often hard to disentangle. So I would like to hear from you if you intend to make like a data analysis based on your sample and your field work, if about the balance of borrowing mechanisms among countries or regions, and if based on your sample, on your experience in these countries, if we could find any potential reason for that, for not balancing the borrowing. So one can see that the case selection you use in the book is not an exhaustive list, it's just mere examples you said, but this is predominantly focused on African, Asian, Latin American, and Eastern Europe countries. So that could potentially indicate that we have this unbalanced borrowing phenomenon when coming to global countries and regions. And if it's the case, you agree that this borrowing is not balanced among countries and regions, I would like to ask, besides the colonial perspective that is more popular in literature, maybe the political spectrum of autocrats would be an important variable to take into account to see how the borrowing is executed among countries. For example, you mentioned that Orban has adopted a discourse that is consistently disillusioned and contemptuous on the West, and the practice of liberal democratic constitutionalism in a more nationalist way. On the other hand, in the case study of Rafael Correa in Ecuador, he engaged in a more jus communi perspective, using the sham-like commitment to environmental rights. So in that sense, I would like to hear from you if this political spectrum would be something to analyze this data. And my second comment is dedicated to your experience on the methodological challenges faced in this project, and mainly on how to choose interviewers for a project like that and how to conduct field work in these countries. So the reason for that, I read the comments of Mark Tushnet on the book, and he mentions that you selected experts that tends to be opponents of the regime. So I would like to hear from you if really was your intention to choose different political perspectives, or the opponents would be more prompt to give idea you needed for your argument, and also how you managed to deal with the fact that the interviews you had, these people were living in these countries, and how would be their bias to lightening their critics, so to avoid retaliation from the government or something like this. So I would like to ask these two questions, and thank you again for inviting me on this panel. And this is an amazing piece of work, and I'm pretty excited to hear about from you.
Thank you, Karina. Please, David and Ross, would you like to react?
Thanks, Karina. Thanks, Pedro. David, do you want to go? Should I go first?
Sure, I can chime in. These are great comments. Thanks for them. There's other really interesting things that kind of, I think, expand on it and lead to projects that would come out of the book, hopefully, right, in the future. I mean, I thought there's a few points there that I would highlight, right? I think in your really interesting comments. The first is different types of authoritarians, in a sense, right? That there are different, there's internal diversity in terms of how authoritarian actors are using or abusing liberal democratic norms, and the balance between that and other forms of borrowing that, for example, are more directly anti-democratic or authoritarian in nature. Because what's really interesting about these cases is there's a coexistence of this abuse of liberal democratic norms with other networks and forms of borrowing that are just directly, kind of more directly anti-democratic in nature, right? And I think the coexistence between those two, and Orban is a fascinating example of that dualism, needs more work, right? Is what I would say is a sort of cop-out. I think you're right that there are significant differences between, for example, the way Correa is using environmental norms, even the way an actor like Kagame is using hate speech and gender quotas, right, versus what Orban is doing. Those are quite different. They have different goals. Kagame is a fascinating case of a regime that tried and actually succeeded to a considerable degree in getting international attention and respect and kind of celebration because of perceived and to some degree kind of real progress with respect to a certain set of issues, where then the same interest groups kind of turned a blind eye to the fact that these were being used to consolidate authoritarianism, right? So that's a kind of interesting dynamic. Whereas Oregon is playing a different game. It's kind of like you have to appease the European institutions who are watching you, right? Kind of supervising what you're doing. To some degree, you're playing with domestic constituencies who have ambivalent views about the West, but you're also very clearly you're defining yourself openly as an illiberal democracy, right? And you are also playing a game where you're allying yourself with actors with openly authoritarian actors. And so that set of differences, I think, is fascinating. I don't know if those are strategic differences, if those are regional differences, or if those have to do with differences in authoritarian regimes. And I think it's a great question for subsequent work. I would treat them methodological questions as well, which I think are really interesting. But Roz, I don't know if you wanted to chime in on this point or that one.
Sure, I'll take the Mark Tushnet attacking us point. I think on the first, I just want to add to what David said is, I think we did notice different pathways, and that again is another topic that other people and or us can do in the future as a kind of more close read of particular cases. So for instance, in Rwanda, we did some interviews where we're pretty confident that some of the anti-genocide laws that were used to suppress political opposition, there were sort of genocide denial laws, came from observing the International Criminal Tribunal in Rwanda across the border in Tanzania. So that the Rwandan government was monitoring and watching those developments, and they might have gone, wow, we can use that to kind of dampen down Hutu opposition domestically. So the pathway was a kind of international organization and international human rights across the border, monitoring, borrow. I think it's pretty clear in Latin America, and people like Sergio Verdugo have done interesting work on this, that, Colombia looms large on the, in Latin America, earlier Costa Rica in relation to the UCA. There's an especially in the Spanish speaking world, right? There's a kind of inter-regional comparison going on, and it's conferences and education and people being able to read and sort of debate other people's decisions and papers. It's very different if you think about Thailand, where some of it's going to be kind of US funded international development projects and education and et cetera. So I think our claim is that we live in an era of globalization, or that is almost always true, but the ways in which ideas travel vary by context and by continent. And that we deliberately decided not to try and do a precise genealogy for each of our ideas, knowing that that is important work that is yet still to be done and can be done by us and others in the future. On the method point, I want to be clear. We did speak to a few people as part of the research, but it wasn't primarily interview based. It was, documentary. It was looking at cases and context and relying on a range of secondary sources. And most of the sources we were able to read in either Spanish or English. Thailand and Cambodia were the exception to that. But there's a good dense network of researchers in Australia and in Southeast Asia who have engaged with Thailand in particular. And so you get both sides. Mark's critique is really a little bit more. So I think this, Karina, a better answer for our book, but a less satisfactory answer for what you should do and others should do in their research. So for our book, we basically tried to engage with all of the available material that we could read. So we can't read Hungarian and Polish from everyone, right? We didn't go, let's look at more, of the dissent versus the government supporters. We just read everything. Now, of course, academics don't tend to be big defenders of fascist regimes. There's exceptions, but like there's not an ordinary distribution, a normal distribution of scholarly writings about the erosion of democracy. And so Mark's critique is that we kind of oversample critique because that's who academics are, especially academics who can write in English and go to global conferences, are kind of cosmopolitan liberals. And that if we are going to make meaningful judgments, we have to be able to speak Polish and Hungarian and Portuguese. And to some extent, we agree with him, right? So that's why we are like, we didn't do Brazil, we left it for you guys to help us think about Brazil. But there's also a degree of kind of nihilism to the response that Mark has that we disagree with, right? Which is comparison is necessarily tricky when it comes to knowing what's going on in a range of countries. And we think that means you do two things. One is don't engage with research on countries you have no knowledge of or feel for or no background in. And secondly, you know, make sure that you really try and read comprehensively and engage with everything available. And the thing I said to Mark that he does note in a footnote in his writing by candlelight piece, and that we reiterate to him in our response, is if you're a good constitutional lawyer, you know the moves, right? So it's like you can predict that the opposition is going to defend it one way and the government another, and you have to anticipate the possibility of reasonable disagreement about your characterization. And we do that for Poland, for Israel, for Thailand, etc. So I would say that in general, the way we dealt with it is not perfect, but it's good enough to make progress. And in terms of what advice that means is the following: try and talk to everyone you can talk to, and be mindful that you have to sample internal, external. If you're talking to a Supreme Court, you don't just ask the judges, how's the court going? They're going to say, great. You've got to talk to observers of the court and critics as well as participants. So internal, external, and ideally as many people who defend and critique the institution as possible, knowing that, for some actions, they're not going to be very many defenders. And the ethics of talking to people who are the defenders is tricky, right? So in one of the interviews I did, I talked to a lawyer who's now an academic, who was very close to the regime in Fiji, the authoritarian regime, and defended the legality of the coup. And I was quite delighted to do it via Zoom rather than in person, because a lot of people have been kicked out of Fiji for asking questions like this. But I basically said to her, look, I'm going to put it to you. I'm going to let you know that my research is not very sympathetic to you. But I want to hear how you would explain your approach. And I want to give essentially you the right of reply to understand where you were coming from. And I hope she never reads the book, but if she does, there's nothing in it she would be surprised by. And one of the things we say is, very carefully, we say something could be abusive in a way that is not abusive in the ordinary language of it, meaning some people may, in good faith, believe that other interests are more important than democracy in a particular context, where they knowingly downgrade democracy, but without having broader political bad faith. And so that's a design to kind of acknowledge her perspective. But you have to be really careful about talking to people who are still in the country. And, the good thing is most universities really put you through a lot of hoops to make sure that those things are really well thought out, but it's really tricky. And that is a reason why you have to rely on both the diaspora and also documentary sources, and where you probably can't write about countries where the regime is currently persecuting academics and there aren't good written sources, because that combination makes it very, very difficult. But, there's no perfect answer. Someone said to us, and to me in particular, about the Rwanda research. They're like, oh, you need to go and do field work. I'm like, there's no way I'm going to do field work in Rwanda. Like, it's too dangerous. And there's nothing I could learn there that would be consistent with not endangering the people I spoke with. And the good news in relation to Latin America is David's done a lot of the field work earlier and has a lot of the background. So for instance, I wrote something in the book about Ecuador and environmental rights, and David was like, that has to be wrong. And he's like, yeah, I don't believe you. And he went and, you know, spent a lot of time kind of going back to his more fieldwork-based knowledge and contacts and information to say, oh, actually, you're right. And obviously he, you know, nuanced the story and, you know, added to it and improved it. But it was that kind of cross-checking of our own intuitions, but also being able to draw on a broader network. And, you know, I did a lot of work on Thailand. Like I had people who openly disagree with each other in print, and I had them comment on it at a workshop where they sort of went toe-to-toe disagreeing with each other as well as me. And stuff like that's really useful, right? Because you want to know. And that's also another way to avoid the danger, right? You don't have to interview someone. If you write something, you ask them to comment on, or you invite them to a panel, and then you see if they're really angry, you get a sense of like, okay, I've missed something here, or this is really hot button, etc. So none of those are perfect answers, but I hope that's helpful.
Thank you. Just before giving the word to Professor Conrado, I'd like to stress that we are keeping track of time, but I think if all of you are okay with it, after Conrado's interaction, we can try to have a last round of questions from the audience and then go to your final comments. So thank you very much again, Professor Conrado, the first one to present a paper here. Thank you.
Thank you, Daniel. Thank you, all the PósDebate organizers. It's been a pleasure to have been witnessing the creation of this group, and it has been something innovative in our postgraduate tradition. And of course, it's a pleasure to be with Ros and David. I read both the original paper of David about abusive constitutionalism, which has become very influential in some constitutional law circles. Here in Brazil, a supervisee of mine is discussing right now whether a very hardcore austerity mindset constitutional amendment, which establishes a ceiling for welfare investments and financing social rights, is discussing whether that is abusive. It's been an interesting question. And I also read your co-authored paper on judicial review, and unfortunately I haven't read the book, although I purchased it and have already looked at it and table of contents, and I look forward to it. So I'll keep it short. I have three points. The last one I'll try to imagine the Brazilian case and how much your categories are reflecting here, or how much there are specific phenomenon which perhaps can fit within the spectrum of constitutional or abusive constitutionalism, but we need to do more typologies and more characterization because they have been interesting. But anyway, the first point is about, I think both Ros and David have already commented a little bit on that. Basically, is the comparative purchase of the concept of abusive judicial review. And I think you state an important insight and methodological point of departure, which basically claims that abusive change cannot be defined, cannot be listed in the abstract, only contextually. And I was wondering, well, perhaps it is possible to go a little further in the sort of context-sensitive approach, because not only the notion of abuse may be very contextual, but also, of course, the very notion of what is the minimum core that democracy requires. It can also be very contextual, and I'm not saying that each jurisdiction defines what democracy is, but that line drawing in that political culture and legal culture and legal infrastructure might be different. And I know that for comparative purposes, the minimum core conception is useful and necessary. I'm not suggesting replacing it with a more flexible sort of structure. I'm just wondering that it would still be helpful to note that each jurisdiction can also somehow borrow this conceptual tool to construct a thicker measure of abuse. I'm not sure this question is very, very clear, but I was wondering whether this very concept of abuse can also vary along a spectrum which each jurisdiction might define in different ways. My second point is the precise reach of the concept of abusive judicial review, and you know that historically authoritarian regimes have captured and co-opted courts for their purposes. So there is a huge literature on the 20th century authoritarian regimes. And as far as I can see, what is new, what is arguably new in what you are doing, is to detect the role of courts, not inside autocratic regimes, but rather in the process of democratic erosion and backsliding. And perhaps it would be interesting to I haven't read the book, perhaps you have already done that, but I haven't seen that precisely in the paper, to compare what you're doing with what the literature on authoritarianism regarding courts has done. And more precisely, the question here is whether to what extent the notion of abusive judicial review necessarily has to serve a particular autocratic project or a particular autocrat or government, or whether it can simply be abusive for basically ignoring or manipulating law and engaging in the micro-politicking and damaging democracy. So in other words, can it be abusive no matter how much it put democracy at risk or serves an autocrat? Basically, in a nutshell, I'm wondering whether we can draw a distinction between abusive judicial review at the service of a would-be authoritarian and abusive judicial review per se, perhaps not that much harmful in terms of democratic erosion. Of course, perhaps I'm looking at different points of the democracy versus authoritarianism spectrum. The examples you highlight, I guess, are located at a more serious point of the spectrum, closer to the authoritarian pole. But I'm sure the notion of abuse is flexible enough to run across this spectrum. But I wonder whether I'm capturing it right. And finally, some points about Brazil. I think the whole book, and I'm talking about the table of content and some parts of it that I know from the other papers. Of course, that there is a centrality of the concept of abuse. And the concept of abuse, of course, is very familiar concept in the history of law. Not that much, perhaps, in constitutional law, but certainly in private law is very, and so on. And the book talks about abusive constitutional change, abusive constitutional borrowing, abuse of constitutional rights, abusive judicial review, abuse of constituent power. And I was trying to imagine whether or not they illuminate something that is happening in Brazil. And Brazil is running through a clear process of autocratization. It's difficult to gauge or to measure how deep we are right now into that process, how destructive and reversible it is. But there is no doubt we are witnessing this. There is plenty of abuse, and I wonder of what kind. and how comparatively specific are the Brazilian constitutional abuses. So going through the types you mentioned, and I might be wrong in my assessments, but I don't think we have been witnessing in Brazil abusive borrowings. That has not been the case. There has not been proper abusive constitutionalism to the extent that this refers to formal constitutional change that formally undermine the minimum core. There might be some disagreement on recent constitutional amendments, but I would claim that it doesn't affect what you call by minimum core. Then it's an interesting question of whether we are witnessing abuse of constitutional rights. I haven't read the book, so I'm not sure how you conceptualize this, but I'm sure that the language of rights is being abused in several ways in Brazil. First, as a general rhetoric of liberty without responsibility, which has been trying to justify things like refusing to use face masks, not respecting sanitary measures in general, not taking vaccines, not even respecting speed limits in the streets, to take more extreme pre-pandemic sort of discourse. Secondly, there has been for many, many years sort of Bolsonarism avant la lettre, a populist rhetoric against human rights in general, which has been running for more than 20 years, claiming that rights should be bared only by good citizens, model citizens, and so on. So perhaps there is a sort of abuse of constitutional rights. And finally, abusive borrowing of weak judicial review. That's not the Brazilian case at all. And then I started wondering, well, what is happening in Brazil that somehow needs to fit our capacity as comparative constitutional scholars and constitutional lawyers in general, needs to fit our analytical framework. And first, I'll mention 5 things that I see as important for the legal analysis, apart from political analysis. There is a sort of cultural war going on in Brazil, and a cultural war not in the traditional sense of constitutional law, which basically refer to the hard cases of constitutional interpretation, abortion, and religious liberty, and so on, but rather in the sense of a rhetoric of hate, of stigmatization, of intimidation against whatever critic of government, journalists, professors, social activists, and so on. This is one thing that goes at the informal level of incivility that harms very much the very condition of constitutional democracy. A second phenomenon that is going on and being studied and mapped, which I would call institutional harassment. Like it happens in transitional times, denazification, communization, those sorts of trying to have a brainwash in the state bureaucracy, and Bolsonaro's government is doing that. Is sort of requiring from the whole bureaucracy and public officials a sort of a pact of loyalty, and politicizing these bureaucratic bodies for that purpose. A third thing that happens both through intimidation, but also through formal changes, infra-legal, which you mentioned, I know, which I would call a depletion of accountability structures embedded in the administration and so on. A fourth thing I would call sort of legality fatigue, which translates into a practice of, I would describe as a flooding the courts, overwhelming the courts with grossly illegal measures, and actually changing them to control, and being aware that the court will not have enough capital to handle them all. So you put 100 of very illegal measures there, and the court perhaps might be able to control 20 or 30, but the other 70 will remain legal and operating effect. So this sort of blitzkrieg basically undermine the capacity of courts to control. And finally, a more well-known phenomenon in Latin America, which is going on, we can call it militarization, but it actually does not only involve the armed forces, but it also has the police forces, both institutions, which have very different histories, institutional configuration, etc. But both of them are being politicized, but not only politicized and pressed to be loyal partners of the government, but the government itself has been populated with military staff. I will stop here. I just wanted to a few things that I should complement. I'm not sure we can call it abusive constitutional modalities of formal and informal, but below the amendment radar, ways of autocratization and abuse. Yeah, I will stop here. I spoke more than I wanted. Thank you so much.
Thank you very much. Please, Professor David and Ross.
Thanks so much for these. They're also fascinating comments. There's a ton to respond to. I just, because of time, I'll probably just not scratching the surface, honestly. But I do want to respond to a few of the points. I think the point about democracy and how kind of local to make definitions of democracy is an interesting one. I mean, I think it's something we've thought about, you know, and I think the idea, as you mentioned in your comments, there is a value to having as a yardstick a minimalist definition that kind of travels, that focuses on elections, you know, although it expands out from elections. So I would say in a sense is open to understanding. I think it's very important to understand institutional arrangements and the different ways in which those institutional and even cultural differences mean that different moves will impinge on the minimum core, right? In other words, the kinds of moves that will impact the minimum core in significantly do differ across contexts. What we've resisted, I think, to this point is defining democracy differently across different contexts, or using a more maximalist definition of democracy. And I think that's an interesting conversation, but it's one it's a move we defend, right, in the book. I mean, both of us obviously believe in more maximalist definitions of democracy, I think, but as a comparative yardstick, also as a pragmatic one in the following sense, authoritarians often, these kinds of authoritarians at least often claim to be kind of electoral Democrats, if nothing else, you know, so there's a utility to saying you're not, right? And here's why you're not, I think. Types of authoritarianism and the distinct contribution of this project, I think you're right, Conrado, that it is about the way in which judicial review is involved in processes of change, right? And the way in which courts can undermine democracy. And we don't have a completely worked out theory, I think, at this point of the different roles that courts play at those different moments of authoritarianism. But I think we do have some ideas, right, that have come out of some of the work we've done. I mean, one of them I think is interesting is that, you know, one of the things that comes out of the literature on authoritarian use of courts is that authoritarians can sometimes afford kind of enclaves of independence, right, precisely because they're established. That's like, you know, some of the Tamir Mustafa's work, for example, and there's kind of a long tradition of showing the different ways in which authoritarians might surprisingly allow independence. I think one thing that's interesting with respect to abusive judicial review and the use of the courts to attack democracy at least in certain contexts, there may actually be more pressure to attack the court. This is consistent with some of the work that's done in transitional contexts, like in Eastern Europe and the post-Soviet world, where like they find that actually more partisan competition undermines judicial independence in those transitional contexts. I think perhaps because in those contexts, there's kind of a scramble where it's like the courts are going to become a key instrument in establishing which of those parties ends up kind of dominating the landscape. So you get an inversion of the normal relationship between partisan competition and judicial independence. And I think some of that's consistent with what we're saying. Now, that said, you don't see abusive judicial review in every case. The courts aren't turned to in every project of democratic erosion. And I think an interesting pending question is kind of why. I mean, we've identified some of the trade-offs, I think, in the paper, but I think there's, some further work to be done, definitely along those lines. I'll turn it over to Roz for.
Thanks, David. I mean, Conrado, really rich comments, and we're so grateful for all of those observations. I mean, I think that there's a little bit of a tension between wanting the idea of the minimum core and abuse to cover a wide variety of practices and to keeping it tight enough that it's capable of attracting agreement across the political spectrum and in ways that are kind of consistently consensus-based. One of the things we say in our 2015 article on the unconstitutional amendment doctrine is that it surely permits of regional and historical variation. So for instance, in Latin America, term limits have a particularly salient history in relation to presidentialism, which might mean that they're absolutely part of the minimum core, where globally their status might be more debatable. So they do have to take into account relevant history and context, and we say that from the outset. There's also a danger to calling everything that we don't like abusive. And certainly the examples of liberty without responsibility would be an instance of where we would say that's an abuse of the idea of rights, but it's not abusive in the sense that we mean, right? Failure to respect the rights of other citizens in a public health context is a failure to appreciate democratic duties as well as rights, but it isn't an immediate threat to electoral democracy in the way that we're focused on. So I think we both agree with you and resist using this label to describe all of the things that we disagree with, because I think doing that then polarizes the debate in ways that deprive this as a standard that should be capable of being endorsed by conservatives and progressives alike as a standard for identifying clear abuses. And I think that the problem with any form of abusive constitutional change is if if it's too late, the court's captured. That's the authoritarian literature, right? There's nothing to be done. And yet too early on, it's hard to see the danger. And I think if we're at a moment in Brazil where that's not the case for the court, it might be in the future, but I think the bigger danger has been around impeachment, and that actually the sort of integrity, rule of law, anti-corruption discourse has been used against Rousseff and Lula in ways that would fit our pattern of increasingly abusive, right? And that the kind of prosecution and exclusion of Lula from the last presidential election could easily be fitted within a broader pattern of abusive constitutional change. But I want to, have time for other questions and comments. I'm afraid I have another appointment that someone's just trying to get me to pay attention to. Do you want to ask David and I'll come back in 5 minutes, or David, do you also have to wind up?
I can stay at least a few more minutes if we take like one round of questions. It's totally up to the organizers.
That sounds fine to us, yeah.
Okay, I'll come back on in 1 second.
Okay, thank you very much. Before giving a word for final remarks, Dan, I'll make use of my moderating powers here, maybe not to abuse them. Just one very small question, and if anyone else has a question, please raise your hand or just send it in the chat box. So David, one thing that I found interesting in the book that was not untangled today yet was when you make the distinction between curbing and packing techniques, and then you talk about the Hungarian, Polish cases, and you see some kind of tendency for a sequence, one-punch strategy of curbing followed by packing techniques in order first to tame the court and then to bring them to their side by authoritarians. My objective question would be, do you think that this is maybe a broader tendency that can be examined empirically? Maybe does it have any predictive power in your opinion? And do you think that, have you thought about certain requirements that have to be met in order to follow the second strategy, such as being a second term, being elected twice, not once? I don't know. Daniel Capek just made a question, if you want to speak, or okay, let me read it. Do you think that there is a connection between systems of government and the different uses of abusive judicial review? Does the system of government produces any constraint in the possibilities of abusive borrowing? In your research, is this a relevant variable? I think that's it. And then just to stress that maybe after David speaks, we can have final remarks by everyone. Thank you, David.
Thanks so much. These are both great questions. So I would take maybe Daniel's question, I guess first, right? Do we observe any kind of differences in political systems that actually make a difference in possibilities for abusive judicial review, right? And I think it's really interesting. The book is not mainly focused on those kinds of institutional differences, but my gut instinct is kind of like, not much, honestly, and that may be kind of depressing, right? That it's not an issue primarily that can be controlled by institutional design. In the following sense, like, you clearly see these dynamics in both presidential and parliamentary systems. I don't think that would surprise anybody, right? We kind of know that at that point. I mean, these debates about stability are old ones, but there's clearly examples of these dynamics across systems. You might think, like, what about strong fourth branch institutions? That you could see those things as checks or controls. But I think the irony is those things, once captured, become promulgators of this kind of stuff, right? So it's not, we write on abusive judicial review, but there's also, you could imagine a project of like abusive electoral commissions, right? Or abusive ombudspersons. And there are examples of those kinds of things, right? Or abusive media commissions. So all of these, ironically, kind of fourth branch institutions that are seen as protectors of democracy can be, under certain conditions, turned into pretty effective tools to attack democracy as well. And that's kind of a depressing realization when you realize I guess it just hammers a point that we all know intuitively, which is the limitations of constitutional design, right? In an area like this, exactly the same sophisticated designs and ideas that are intended to bolster democracy can actually become pretty efficient ways to attack it. That conclusion, when you say it out loud, sounds almost nihilistic, right? Like it's depressing. But I think there's some truth to this. And then I don't know that, Roz and I have a lot of projects on constitutional design where we think about ways to make constitutions more robust against these kind of dynamics. I think they do exist, right? But they rely on strategies that are complex, like splitting, making institutions harder to capture, for example, in various ways through kind of splitting authority between different institutions. In other words, one reason to create fourth branch institutions may actually be not that they can't be captured, but it's a little harder to capture like all of them, especially if you create different appointment rules for different institutions. there are ways to get around all of those problems, right? But that's, if you're thinking about how to make a constitution relatively robust, that's a strategy that may bear some promise, although it may also make your constitutional order less efficient against other kinds of, in other kinds of contexts and against other kinds of threats, right? Now, as for the statement on like the kind of shoe punch or how you see courts get attacked, I think, you know, it's really, what we did was just kind of observe the empirical regularity of what happened in Hungary and Poland, I think. And it has a logic, which is before you can control the court, you attack it. And once you can control it, right, then it's a useful instrument for you. I don't know whether you'd observe it elsewhere. I think, you know, I'm trying to think about the Latin American cases, and I think to a degree in places like Venezuela, you observe this, right, before Chavez was able to fully control the court. So, because it makes sense, right? But I think what it really highlights, this sort of 1-2, like curb then pack, what it kind of highlights are the trade-offs implicit in regime attempts to take over courts. It's not a costless strategy, right? There's no kind of perfect way to do it. And the interesting thing about the 1-2 is that it to some degree runs down the legitimacy of the court before you take it over, right? Which is kind of a limitation on the strategy itself, but it may be one that's kind of necessary in some contexts for the strategy to work. So I mean, I wouldn't expect to observe it everywhere, but I think you would. I think it makes sense in a particular context where it takes a while to take over a court. You know, that like the first step would be attacking the court's powers. And then once you get control of it, you actually want to build it up, ironically, at that point, because you've weaponized it. So you may want to actually make it stronger, but doing those two things in sequence is a very tricky thing to do.
Okay, thank you, Professor. Since we're reaching our time limit, maybe we should wrap up. I'd like to thank Professors David and Rosalind and Professors Diego, Conrado, and Karina. And before we end, I'd like to ask if you have any final comments. If you don't, and if the audience also doesn't have, maybe then I just like to thank again everyone, and yeah, thank the audience for being here too. And that's it. I don't know. Daniel, do you want to say anything?
I'm fine. Thank you very much. Bye-bye.
Thank you, David.
Thank you.
Thank you so much. Bye. Thank you.
Bye.
Bye.